Ladies and gentlemen, are Muslim women entitled to alimony? Now, this is a question that has been debated in and out of courts in India for the last 40 years now. Today, the Supreme Court made it absolutely clear. When it comes to the rights of Muslim women, the secular law of the land will supersede the narrow and discriminatory special act that denied them alimony. Now, this is a big deal because of just how clear the Supreme Court has been today. The court has said that maintenance is not charity, but the right of divorced women. It has further gone on to say that the Muslim Women Act 1986 will not prevail over the secular and religion-neutral provisions of Section 125 of the CRPC. I don't mean to confuse you or complicate this for you. Let me explain what this means. It will require us to go back to 39 years, to 1985, but just bear with me for the next 2 minutes. When it comes to Muslim women, the question of their alimony gets sandwiched between two laws. One, that is the secular law of the land that applies to all women. And the other, a special act which was brought in by the Rajiv Gandhi government in 1986 that applies specially to Muslim women. The 1986 Act was called the Muslim Women Act, but it did exactly the opposite of what the name suggests. In an act of appeasement to Muslim clerics and politicians, this Act of 1986, passed by Parliament, denied Muslim women the right to alimony beyond the iddat period, that is 90 days. Now, this act was brought in to water down the Supreme Court judgment on the Shah Banu case, which was a very progressive one because it had granted maintenance to 62-year-old Shah Banu who had 5 kids in contradiction to Islamic law. So, there is the Special Act of 1986, but then there is also the secular law of this land that under 125 CRPC gives all women the right to maintenance. The Supreme Court, therefore, today has made it very clear that the secular law of the land is above any special act, and it applies to all women, irrespective of their religion. Now, today's judgment has come in response to a plea by a man from Telangana who had challenged the 10,000 rupee alimony that the High Court had asked him to pay his divorced wife. But the larger ramifications of this order cannot be ignored, given that it sets the ground for one nation, one law, at least when it comes to marriage and maintenance. That is something we'll talk about, but for the moment, I'm going across to Wasim Qadri, who is the petitioner's arguing counsel, also a senior lawyer at the Supreme Court, joining us on the broadcast. Mr. Wasim Qadri, thank you very much. A lot of people, many people are saying this is a landmark judgment. In your view, is this a landmark judgment and why?
Yeah, this is landmark judgment because of the reason that this judgment is not dealing only with the small issue whether a divorced Muslim lady is entitled to file application for maintenance under Section 125 of the CRPC or not. This is not the only issue which has been decided in the judgment. This issue has been decided. In fact, there is a settled law. There were some conflicting judgments. So finally, Supreme Court has given two judge have simply decided on the basis of previous judgment. One of the constitutional judgment is there, but Justice Nagarathna has given a separate judgment where she is dealing with the common, it is like a woman empowerment. She is not talking about the Muslim divorced woman or Muslim woman. She is talking about the general common people, common means the lady, whether she is divorced or she is not divorced. She has, she is saying that for the purpose of social justice, for their upliftment, what should be done. And she has explained in the judgment,
Okay.
which has never been explained in any other judgment.
Mr. Kadri, I just want to point out to our viewers that the judgment today was actually against you. But you're still saying this is a landmark judgment, and you're saying it's not just because of what the Supreme Court has said and done when it comes to alimony for Muslim women, but for all women in this country.
See, in this judgment, there is a special feature which says that if a lady, even during the subsistence of the marriage, because the issue of maintenance arises when somebody is divorced or somebody is deserted, right? But this judgment talks about a lady where the marriage is subsisting, both are living together, but court is saying that the lady who has no source of income, she is maintaining house, she is a housewife, a separate account should be opened, and some amount towards the day-to-day expenses should be deposited, ATM may be opened, something like that. These are mentioned in the judgment. So this is a special feature. And this does not talk about the Muslim woman or divorced Muslim woman. It talks about the common woman, which will be applicable upon each and every lady who has no source of income.
Mr. Kadri, but I just want to point out to you and all our viewers as well that these were just observations. There is no judgment that says that husbands now have to have joint accounts with wives or they have to share the ATM pins with their wives.
These observations has been made on the basis of previous judgment, and it talks about the social justice. So even if there is no direction, it will have a persuasive value. And like, a presidential reference. Presidential reference is given by the President of India, and 5 judges give a judgment on that. It is not binding, but it has a persuasive value. Similarly, in this case, it has a persuasive value, and it can always be any time a lady who wants some help, she can take help of this judgment, and no lower court will dare to ignore it.
Okay, Mr. Kadri, we'll see, we'll see the impact of that judgment and the observations as we go along. Thank you very much. So, ladies and gentlemen, this is what I've done. Today's judgment is in 2 parts. One, it is very clearly saying that Muslim women deserve alimony. It is their right. So the first part of our discussion, about 10 minutes, is going to be about that. And then the next part of our discussion is going to be about the larger picture that the Supreme Court has painted for us as far as homemakers are concerned. The Supreme Court is making some very important and valid points about how homemakers often are made to feel financially insecure. Many of them actually leave their jobs to bring up their families. In this case, there needs to be a mechanism to make them more secure. But that is something we'll talk about after 10 minutes. For the moment, introducing Shalini Ali, who is the national convener of MRM, joining us on the broadcast. And Sarfaraz Wani is a lawyer joining us on the broadcast as well. Dr. Zeenat Shaukat Ali is an Islamic scholar. I want to start with Sarfaraz first and just get the contrarian view in. Sarfaraz, why are Muslim clerics, why are many Muslim men saying that what the Supreme Court has said and done today is in contradiction with Islamic law? Even if it is in contradiction with Islamic law, the fact is it benefits Muslim women.
See, Shalini, I will call today's judgment as a sheer incursion into the personal laws of Muslims. And there is a reason for that. See, the topic of marriage, the topic of inheritance, the topic of divorce, they are all governed by personal laws. Whether a Muslim wants to marry 4 women, a Hindu wants to can only marry 1 woman. Similarly, there are certain areas which are governed by your personal laws. My religion tells me something. The religion of Hindus tells them something else. The religion of Christians tells them something else. Now, my point is, if my religion tells me marriage is a contract, there is a procedure for that. I follow the procedure, and after, because of certain things, the contract ends. And there is a period of iddat of 90 days where I am supposed to maintain my wife. for that period, and after that I'm not supposed to maintain. And which text tells me this is my religion? Now, I am telling you, why are you encouraging my personal laws now? If I have divorced, I have decided to remarry, and that woman has a choice now, she can also get married. Why
ठीक
my
है,
personal laws are being violated?
ठीक है,
Why I am
ठीक
being
है.
forced to
Here,
maintain
here.
her? Suppose a
Okay,
Muslim.
I'll
Now
put
I
that
will give you.
question to
Let me
Dr.
explain.
Zeenat Ali. नहीं, रुक जाओ,
Let
रुक
me
जाओ, रुक
explain
जाओ,
this
रुक जाओ.
point.
Just a minute. नहीं, नहीं, नहीं. We'll hear the explanation in just a bit. You have made a point. I need to get the point counterpointed. My limited point would be, yes, there are personal laws. Yes, 100% there are personal laws. The Constitution guarantees you personal laws. But then there is the secular law of the land as well. And if these two are in contradiction, somehow it is the law of the land that has to prevail, my dear friend. Anyhow, Dr. Zeenat Shaukat Ali,
Not
would
at
you
all.
want to come in here? This is an argument you've heard a million times. And I can see Mr. Wani shake his head as well when I make the comment that I did.
Yeah. Yeah, thank you. Thank you for inviting me to the show. You see, the first thing that I would like to say is that this entire misapprehension, miscomprehension, misleading arguments that are bringing brought forth, that the personal law of the Muslims is in consonance with the law of Islam. There are two different approaches and attitudes altogether. Islam has never spoken about the triple divorce, and yet it is here. Islam has never spoken about treating women the way you treat women. And, even coming to this point of maintenance, speaks very highly of charity. It is one of the pillars, zakat is one of the pillars of Islam. And here you have a destitute woman with whom you have lived, with your children, but after 90 days you throw her out, uttering three words, and then saying that this is a law that the Prophet taught. The Prophet toppled such laws. Pre-Islamic Arabia had laws where women were suppressed, girls were buried alive, and women had no rights. The rights were given to Muslim women, and unfortunately, because of the male patriarchy dominating and the lack of education and the Sharia law being frozen 200 years after Prophet Muhammad, may peace be upon him, passed away, that contrary laws have been brought in. Now, for 75 years in India, we are living with that. And why are we living with that? Because Islam is not misogynistic, it is not patriarchal, it is giving women rights. It is giving women equal rights. And here you have a woman who has given up her job or given up, and she's living with you, and you don't have the courtesy or the humanity to say that, yes, I will look after you, and we are there is a verse on marriage with the way the Quran says that we have put love and mercy in your hearts for each other. Take care of each other. You're like garments to each other. Now, what kind of an understanding is this gentleman bringing along? I don't mean him, my apologies. I mean this general trend that, disturbs me greatly. Where Islam has given you those rights, but those rights have been diminished and taken away, misinterpreted, and made misogynistic. And yet we are made to say, yes, those are the only laws that can prevail because personal
Dr.
laws
Shaukat Ali
are going to be followed.
Dr. Shaukat Ali, then very quickly, then could you help me understand why today's judgment is so important? It's not like courts in the past from 1985 to now have not given Muslim women the right to alimony or maintenance. It's happened. So why is today's judgment so important? Is it so important because it makes it very clear?
Yeah, absolutely. It draws a straight, because you see what is sadly that despite all these judgments coming in, we still living this ambiguity, you see. And this law draws a line against that ambiguity that should not have existed after these other laws were brought about. Even in 2019, the triple talaq, was penalized. It was, banished and penalized as it should be. But the point remains here is that it is important because of this, because of the reiteration and because of the drawing the tight line that all women are, equal. And as it was stated, that a married woman also, she has rights in her family. She's not a chattel that you have brought. And please, I'd like to clarify one thing. A Muslim woman, when she marries a man, she doesn't come as a servant. She's not there to cook for him, and she's not there to cook for the family, and she's not there to sweep and swap. It is made very clear if you look into the life of the Prophet Muhammad, may peace be upon him, all his wives had different residences. They were given all the rights, you know, all the knowledge was spread by them. They were social workers. Hazrat Aisha, radiallahu ta'ala, fought a war. So, I mean, this was the state, this is the
Okay.
state of Muslim women. And today, what we are reduced to is something that, absolutely, profoundly, grieves me and my soul.
Okay,
So this
Shalini
judgment
Ali
becomes
then,
extremely
Shalini Ali then, does this,
point of equality.
for clarity, because there's been so much ambiguity that this
Clarity, that's
judgment
right.
makes things very clear.
There are 2 points,
That-
Shreya, I would like to make on
that's
record.
the, I think, Shalini, before you come into the 2 points, I have a simple question to you. Does this judgment then lay the foundation of one nation, one law, at least when it comes to divorce and alimony?
Absolutely right. And that is the need of the hour. We need one nation and one law. UCC is important because the problem that we have is the interpretation. The major misusing of the Quran for interpretation, misuses of the law. I'm going to tell you the first point. The provision in question is Section 3(1)(a) of the Muslim Women Protection of Rights Divorce Act 1986. Now, what does it state? It states the reasonable and fair provision and maintenance to be made and paid to her within the iddat period by the former husband. But the court held this
Correct.
provision means that a reasonable and fair provision maintenance is not limited to the iddat period. He has to pay for the rest of the life till she remarries. And that is exactly, that has been forfeited by the Qazis and the Maulanas. Now, why is it important? Today's judgment that has come in, after so many years, I mean, look at what has happened. They have taken women right out of any religion into one section that they are not objects. They are human beings. They need respect. They need to live a life which has to be led in a proper, gratified manner. You can't use a woman and throw her away. Okay, fine. If she's working, if she's independent, many girls today are not even filing for maintenance because they are on their own 2 feet. The need of the hour is education and educating people, ladies who are still victims of triple talaq, ladies who have been deserted, who are probably forcing themselves on begging, for getting money.
Shalini.
This is the need of the hour.
Okay, it's all very well, and I'm going to wrap this debate here. I think we've heard from all three sides, but here's my limited point. It's all very clear, all very well for the Supreme Court to make things absolutely clear when it comes to alimony for Muslim women and maintenance for Muslim women. So thumbs up to the Supreme Court for doing that. But here's the reality, ladies and gentlemen. Do you know any woman who's out there fighting a court case to get alimony, to get maintenance? It takes 20 years, 25 years to do it. So the Supreme Court would be well advised, and I'm in no position to advise the Supreme Court, but the Supreme Court would be well advised to look into this aspect and at least fast track that. Plus, there are no codes on how much, alimony needs to be paid. In the US, there are codes. In India, jo manglo, nahi mango, there is no fixed amount, there is no calculation, there is no formula. That needs to be fixed by the Supreme Court as well. So I hope if the Supreme Court is listening to my humble opinion, it needs to look into these two things as well. But, ladies and gentlemen, there's much more to unpack in the Supreme Court's order today, because it has implications not just for Muslim women, but for all homemakers. In its order, the bench of Justice B.V. Nagarathna and Justice George Masih observed that the time has come for Indian men to recognize the indispensable role played by homemakers and the sacrifices they make for their families. This has to be done, they say, by giving his wife access to his financial resources, whether it is through holding joint bank accounts or sharing ATM cards. Ladies and gentlemen, the issue of unpaid domestic labor is something we all need to pay attention to. Actually, a recent report by the National Statistic Office, and it is called the Time Use in India 2019, is suggesting that on an average, women spend nearly 299 minutes a day on unpaid domestic services for household members versus 97 minutes by men. Should I repeat that? On an average, women spend 299 minutes a day on unpaid domestic services for household members like in-laws, parents, kids, versus 97 minutes by men. Similarly, in a day, women spend 134 minutes on unpaid caregiving services for household members as compared to 76 minutes by men. Clearly, it's time to make household duties equitable, if not equal. If the fruits of the wife's domestic labor are shared by the husband, then shouldn't his finances be shared by the wife as well? It's a talking point. Barkha Trehan is joining me on the broadcast. Dr. Zeenat Shaukat Ali continues to be with us, and Niharika Karanjawala is a principal associate at Karanjawala Co, joining us on the broadcast as well. Niharika, I'm welcoming you to the show as well. These are, again, I just need to tell our viewers, these are observations, but these are big observations, and I don't think I've heard any court say these things before. So it's significant in that sense.
Absolutely. These are very significant observations for homemakers across the board. It's a very important step forward that the Honorable Court has taken. And they've also given suggestions on how this can be implemented, such as access to a joint bank account, access to an ATM card. Let's not forget, Shreya, that what the court has also taken into account is, without saying it specifically, there are a great number of cases of abusive marriages in which a woman is unable to leave because there will be a complete lack of financial independence for her if she chooses to do so. And a measure like this will also help situations of that sort. So I feel that the court has taken an extremely practical view here and given an observation and a suggestion to move forward the ground situation for homemakers. It's a very, very welcome observation.
Barkha Trehan, would you want to come in here?
Hello. Yeah, I couldn't hear the question. I've just joined.
Hi, Barkha.
Hi.
Acha, koi baat nahi. So, hi. You know what has happened in the Supreme Court, right? You're aware of what the Supreme Court has said. This was a case relating to Muslim women and alimony, so there's a landmark judgment there. But what has also become a talking point, Barkha, is the fact that the Supreme Court has spoken on all homemakers, not just Muslim women, to say that many homemakers actually quit their jobs to bring up their families. And then it needs to be ensured that they are financially stable and secure. So one of the suggestions that the court, for example, has given is that husbands can possibly have joint accounts with their wives and joint ATM cards as well. Nothing wrong in that, right? We need to recognize the unpaid labor of housewives.
See, Shreya, we've always been talking about women's rights. What about husbands' rights? Are they just sperm donors and ATM machines? We always think that we have to get that money. It's fine to have a dual card, but what are the responsibility and rights of a woman? They refuse to do household work. They refuse to take care. In many cases, I'm telling you, they refuse to take care of children. They leave 3-month-old child and fly from the house. They move on with their boyfriends. They kill their husbands. So are we determining any of the responsibilities of the wife?
Exceptions.
I'm not talking about exceptions, my dear.
Hey, Barkha, you're talking about exceptions. You're asking me if husbands are just ATM cards, but are wives just house servants who are supposed to cook and clean and bring up children? That's the other point of the argument.
Not at all. Only the NCRB data says that husband suicide is 3 times more. Imagine it's 3 times more and it's going towards 4 times more. And still you think that wives are the becharis, the abla naris. It's not like that. In the 21st century, women are
Barkha, that's not what the court has said.
The court has said
that is not what the court has said. I understand. Let's leave the rhetoric aside. The court is saying that it is time for husbands and Indian men to recognize the work that Indian women put into their homes. The fact that many women leave their jobs to bring up families, they obviously are not drawing a salary, so they are financially unstable and insecure. And in a scenario like this, what men can probably do is have joint accounts and share their ATMs. Isme galat to kuch nahi hai.
See, men also do a lot of sacrifices. Do we ever talk about that? Do we ever think about that? When men are the providers and the protectors, they are giving each and everything at home. Then why do we want a joint account and this and that? This will create more complication in the relationship. And the relationships will break more.
Okay.
Try to understand this aspect
Acha.
of the Indian
Acha, so
society.
okay,
This is
Barkha, so
our
here's the
Indian
data for you.
society.
Barkha, here's the data for you. Since you said कि आदमी काम नहीं करते, since you said that they are providers, etc. So this is data for you. In a day, a woman spends 134 minutes on unpaid caregiving services to her kids, to her parents, to her in-laws, to her husband. What is the figure for men? 134 for women, 76 minutes for men. So I think that answers your question. But I'll let
Okay.
Dr. Zina
I
Chaukat
have
Ali
a
come in
question
as well.
for you,
Dr. Ali,
Shreya ji.
the court, एक मिनट, हाँ, बोलिए जी.
I have a question. What responsibilities does a wife have? We always discuss this. But what are the rights? Sorry, the rights, I'm talking about the rights of wives. So are there any rights of husbands? Where can they go? This is a very
ये क्या सवाल हुआ?
important question.
ये सवाल ही क्या हुआ? I don't know how this is.
Why?
Dr.
live in
Zina
an
Chaukat
equal-
Ali, would you want to respond to that? क्योंकि मुझे तो सवाल ही नहीं समझ आया. But would you want to
society,
respond to
yes,
that
Kumari.
if you have understood what Barkha is trying to ask?
Yes,
Give me a
Barkha,
minute.
While your passion for defense of the male's gender is laudable in a way. I cannot quite fall in line with it, because at this point of time and with this judgment that we are looking at, and with the kind of I'd like to come back to this point about sharing, having bank accounts and sharing cards. No, I would like to point out to you that under Islamic law proper, a woman becomes a rightful property owner if her husband gives her a proper meher. For example, the Prophet Muhammad himself, may peace be upon him, was not a rich man, but he gave his women ample, amount, in the form of either cattle or in the form of any whatever he had to share with them. He gave them. So here, what happens that she becomes a property owner in her own right, and I think that instead of having a joint account, she should be a separate account holder. There should be a separate amount of money that can be put into her name, which she can use her own ATM card, she can use her own credit card. I have my own credit card. My husband gave it to me the moment I was married. And so did my father. But then they were well-off people, so there was nothing for me to talk about. But what I'm talking about is that she is an individual in her own right. Why should she merge into that of her husband? Which is, so far, we have never discussed really who is a husband and who is a wife, and what are they, how do they come together, and how do they under the law of Islam, a woman remains her own person, in the economic sphere and in the legal sphere. She can take action. So what happens is that even if she lends money to her husband or she gives money, there's a certain law that would prevail. So the Islam gives her that right. And so, and I'm talking generally now, coming to the general law, that why should a woman not be a property owner in her own right? But her father, today, when we talk about this dowry system, that, you have these grand weddings where you spend millions and billions, it should be given to the woman, for which she can enjoy her, her status and be an individual, respected, economically independent, and be able to act, on those lines. So this is my opinion, that she should.
I get what you're saying, but Niharika's today. I get you. And I'm sure that's the opinion of many women who are watching as well, except Barkha, of course. Nahi, Barkha, I just want to get in Niharika. Niharika, I understand that is, but a court observation is not going to get that done. So, what purpose does it solve?
Absolutely, Shreya. Court observation is not binding. It's simply an observation that the court is making and certain suggestions that the court is putting forward. I feel that educational campaigns ought to be taken on by the government to move this process forward in its own right. To Barkha's point, I did have something to say, which is, if you take every aspect of something like this, something as essential as rights in a marriage, as a man versus woman thing, then you're not going to get any answers ultimately. I feel that Barkha makes a valid point in terms of men's rights from certain spheres. Like, for example, certain laws are very woman skewed in the sense that women can make accusations that can put men behind bars.
Correct.
That is something that needs to be
Agree.
regulated to ensure that it's not misused. So to that limited extent, I agree with Barkha and I see her point. That's a separate debate, however. That's an entirely separate debate, and one that deserves to be had, one that fully deserves to be had. I just don't know how much significance it has to this aspect that we are discussing today.
Okay. Okay. I agree. I mean, dowry laws, for example, in this country are misused. We all know that, and we agree with Barkha on that. Barkha, out of time, someday we'll discuss dowry laws as well, and I'll get you to speak a little more.
Maintenance to able-bodied
bolo.
women. Why should we pay maintenance or alimony to able-bodied
Because she
women?
has spent the best years of her life looking after your children and cooking for you and your family. We leave it there, Barkha. As I said, this is... God knows how difficult it is to go back to work after 15 years of being at home. Barkha, these are the realities of life, but that's a debate for another time. Barkha Trehan there joining us on the broadcast. Dr. Zeenat Shaukat Ali, thank you very much. And Niharika Karanjawala, thank you very much for joining us as well.